Learned senior advocates here present, very senior professors, distinguished colleagues at the bar. My name is Professor Foluke Dada Lawansin. I know most of you know me as Professor Foluke Dada, but we have added Lawansin. That's just to honor my late father, who wanted to be a lawyer and couldn't become one, but made sure his daughter became a lawyer. So at his passing, we added Lawansin. So when you see Dada Lawansin, it's still the same me. Thank you very much.
Good afternoon, distinguished colleagues, professors, senior advocates of Nigeria. My name is Dr. Rapolo Ndoka. I used to be the National Publicity Secretary of the Nigerian Bar Association. And, well, I believe that we'll be asked maybe what we are trying to consult for. But I'm one of you. I'm your own. So I am here today. Thank you so much.
Good afternoon, learned professors, senior advocates of Nigeria, doctors, my distinguished colleagues. I am not a professor, neither am I a doctor. My name is Nuhu J. Egya, the immediate past chairman, MBA Kefi branch. Kefi branch is in Nasarawa State. The current chairman, Citizens Liberties Committee of National MBA. If you want to know about what the Citizens Liberties has done, you can go online and Google our activities. I'm here to interact with you and consult with you for the second vice president position, if you agree with me that I should run in the next coming election. Thank you so much.
My very learned seniors, professors, learned scholars, doctors, my very learned seniors in this legal profession and colleagues. I am Yakubu Moses Ede, the past MBA chairman of MBA Kefi branch, and also the past secretary of MBA Kefi branch, and also former publicity secretary or pioneer publicity secretary of MBA Kefi branch. Presently, assistant national secretary of the MBA Appeals Committee for North. At the same time, the national secretary of the MBA Judiciary Committee. This is my primary constituency. If I mean primary constituency, meaning NALT, because I am a full-fledged member of this noble association, a lecturer with the Nigerian Law School, particularly in Yenagua campus. So we are here, and we know our capacity, we know what we can do.
Thank you, Mr. Yakubu.
Thank you. If opportunity is given, we'll get there. Thank you.
Thank you. Okay, so, distinguished scholar, if there's any time I would crave your indulgence for absolute silence, for us to have a meaningful conversation and interactions with our aspirants, it would be now. May I humbly request that we pay attention to what our aspirants have to say and to this conversation. It's very important. It goes to the heart of our association and our profession. Thank you. I would like to provide a context as a background to this conversation. The Nigeria legal system stands at a pivotal juncture, demanding not merely practitioners, but ethical, competent, and globally relevant leaders in an era defined by rapid technological change, shifting economic realities, and evolving standards of justice. The quality of education has never been more consequential. It is the pipeline through which the next generation of lawyers, judges, and policymakers emerges, and its health reflects the strength of the profession itself. At the heart of the enterprise stands the Nigerian Bar Association, the foremost professional body of lawyers and the conscience of the legal profession. Beyond its traditional advocacy and regulatory roles, the NBA bears a non-negotiable responsibility of legal practice through its influence on legal education, professional ethics, and continuing development. This is because it has among its core objectives maintenance and defense of the integrity and independence of the bar and the judiciary, promote timely and affordable access to justice, promote and support law reform initiatives, promote and protect the principles of the rule of law and respect of human rights, promote and advance quality and functional legal education, advocacy, and progressive jurisprudence. This session, therefore, will provide a rare opportunity for us to engage with MBA elective office aspirants on their vision for the profession's future, particularly as it concerns us law teachers, curriculum reform, and the interface between academia and practice. It seeks to interrogate how their manifestos respond to the pressing challenges of today's legal education, bridging the gap between theory and practice, embedding digital and ethical competencies, and ensuring that Nigerian legal training aligns with global best practices while serving local realities. The conversation invites the aspirants to move beyond rhetoric, outlining clear, actionable plans to strengthen collaboration between the bar, the bench, and the academia. A tripartite relationship upon which the integrity and dynamism of our legal system depends. The question I have formulated are therefore into three core areas critical to law teachers' curriculum: regulatory reform, faculty development, welfare, and town and gown partnership. So without wasting time, I'd like to go on to Mrs. Badijo for the first question. There is the growing need to integrate artificial intelligence and legal tech in the Nigerian legal system. What specific time-bound regulatory proposals will your administration present to the Council of Legal Education and the National Universities Commission to mandate the teaching of core digital law, artificial intelligence ethics, and data governance courses? And how will the MBA assist faculties with the required electronic infrastructure? Mrs. Badijo.
Thank you very much. I think at the heart of that
I'll give you 3 minutes for that, please.
I beg your pardon?
3 minutes.
I think at the heart of the question is the idea that there are many aspects of the law curriculum right now that are no longer fit for purpose. It seems to me like the curriculum does not move as fast as it ought in terms of the changing realities that lawyers practicing today face. I don't think this is a problem of just the law school. Certainly it's both the law school and the university. So where does the MBA come in? You mentioned when you were reeling out the function of the MBA, one of them is to help to promote robust education that is fit for purpose. And I think the best way that the NBA can do this is by advocacy. Because other agencies have the responsibilities to design curriculum, to ensure that the approved courses are taught. What the NBA can do is to advocate and lobby to ensure that the courses that we're seeing that lawyers in today's Nigeria, in today's world, need to function effectively as legal practitioners are introduced into the curriculum right from the university age. I was looking at the curriculum of a UK university, for example. There are all sorts of courses that are being taught, and it's not just about AI and tech. All sorts of courses that are being taught that address the issues that legal practitioners face today. I think the NBA can play a more pivotal role in collaborating with all the participants, all the players, the NUC, the universities, through the law teachers. It's particularly important to involve the law teachers, and luckily there is NALT that can nominate people who see it from that point of view and see the things that are near to be taught and how they should be taught. And so collaboration would be my first prescription. The details of which will be worked out. I'm not in the habit of prescribing things that are not possible. Put together a tripartite team made up of members of the NBA, members of the NUC, members of the university, both the admin side and the teaching side, so that everybody sits down together and comes up with what is workable and, most importantly, sustainable. That would be my prescription. Thank you.
Thank you for your contribution. You mentioned advocacy, number one. You talked about collaboration, especially a tripartite collaboration to drive the process. And you equally told us that you're going to put in actionable plans, not just theory. And so, okay, we've heard you, but we're still having this conversation. Ordinarily, I would like the question to also go through to the other aspirants, but because of time, I will pose different questions to the aspirants. I'm going to be asking Professor Foluke Dadalawa this question. The MBA is moving toward stricter compliance with mandatory continuing professional development, MCPD. How will your administration structure and subsidize specialized MCPD training specifically for law teachers to ensure their knowledge of the evolving law and practice rules remains current, relevant, and in full compliance with the bar?
Thank you very much. I want to start by saying that continuing legal education should not just be at the doorstep of law teachers or a section of the legal profession. So my answer is going to be very general. And it is important for us to identify the fact that the continuing legal education process that we have at the bar at the moment is working. But can it be better? Yes, we can put it into a better shape and better use. So for me, we need to first of all identify the important and relevant trainings that we need to develop our capacity as lawyers. Right now, we have a process whereby certain organizations are accredited to give trainings. And we have all the sections, the branches that can also assess these points for the use of lawyers. What can we do to make it better? We can ensure, first of all, that the Continuing Legal Education Committee is staffed with people who have the knowledge, the background training. And who are these people? These are law teachers. And I think this is where NALT should play a very big role. We should ensure, as a bar, that we appoint members from NALT into these committees. One, to design the curriculum, to identify the topics, the courses that are relevant, and to ensure that the standards of training are laid down. A situation where you have trainings being announced and people will just log in for the point, the processes of ensuring that the people that actually attend those courses actually gain something important from it is to be put together, because as it is right now, I don't think we're doing enough to ensure that the training is standardized. So we need to encourage our members, our law teachers, to participate at the bar. And that is important. You give me 1 minute to quickly mention this. The academic forum of the bar is very relevant to NALT. I think every member of NALT should be members of the academic forum, because this is the forum at the bar that allows us to air our opinions. So training and teaching, there are specific skill sets that we can apply and actually provide to support the bar. So that is what I would say. And there is more, but I see you're beckoning on me.
Yes, because we have very limited time. Can the DJ please, a round of applause for Prof. Help us with the second mic. It's dead. Okay, so. Okay, all right, I'll come back to you on that. So the vital takeaway from your intervention is that that NALT members should be integrated into the structure of the Institute of Continuing Legal Education for the purposes of the professional development. Thank you. I'm going to pass the mic to the next aspirant. I will give him opportunity to introduce himself because he joined while we had commenced. But before passing on the mic to him, let me quickly ask him the question so that he can take that as well. So, given the recurrent concerns about the quality of law output, what is your blueprint for tripartite review committee of MBA, NALT, CA to overhaul the law school curriculum, focusing on embedding practical skills and professional ethics? I hope you got the question. All right.
Thank you very much. Good afternoon, ladies and gentlemen. My name is Latif Omoyemi Akongbe. I practice out of Lagos State in a law firm called Shofunde Osakwe Ogudegbe and Belgore. I am the managing partner of that law firm, and I was the chairman of the Nigerian Bar Association Lagos branch between 2019 and 2021. I'm happy to be here. I see a lot of friendly and familiar faces. Professor Agoms is right in front of me, and I'm happy to see him. Happy to see people like Professor Shodipo, Professor Abikon, Professor Idonije, our father in arbitration. I'm also an ADR specialist, following footsteps of Professor Idonije. I'm a fellow of the Chartered Institute of Arbitrators, UK, Nigerian branch. So I'm very happy to be here, basically. Let me say that. Your question is a very good one and very important question. I think I'm better suited to talk about this as a practitioner who employs law students, year in, year out. And I say that the MBA needs to pay more particular attention to the curriculum at the law school. The MBA has representatives in many bodies, the Council of Education being one of it, and that's the body that sits on the curriculum of the Nigerian law school. Now, the chairman of that council is currently is Professor Emeka Ngige, SAN, and I think that the MBA should pay more particular attention to what comes out of the law school. What I've found is that the law school, even though its curriculum ought to be on practical stuff, and less theoretical things that are being taught. So I studied law in England, and at the time I was doing my master's, I had friends, I had roommates who were doing the Bar Vocational Council in the UK. And I'm very familiar with the curriculum and what they do. When I see the curriculum there, the sort of things that are being taught are very practical. They teach them how do you present submissions in the Crown Court? How do you present submissions in the High Court? What is a skeletal argument? They're giving scenarios. They bring out skeletal arguments. So basically, they are preparing you for the real life. And I can't think of a better way to produce a lawyer other than that. Because if you look at the historical background and how this profession started, at the beginning, lawyers didn't used to go to universities. It was apprenticeship. You attach yourself to a law firm, and they start teaching you, this is a writ of summons, this is a writ of fife, this is how to draft pleadings. And that's how people became lawyers. Nobody went to university to get a degree. So it's more practical than anything else. When I was in law school, I didn't see what I was being taught as anything serious. I felt that if I could cram everything and regurgitate it, I can come out with a good grade. But in practice, and when people come to my law firm, I have the privilege of having seasoned advocates in my law firm. And when they come on externship, number one, they spend fewer time in law firm than they should spend. And what we tell them is this: when they come, they sit in with us when we have our chambers meeting. And we tell them, you know what, anything you hear from us here, when you get to law school, please do not write it down, otherwise you will fail. Just write down what you're being taught. Don't go and say, this is how they do it in practice. You would fail. But when they come, the first thing we tell them is, everything you learned at the law school, please unlearn it. Come and learn practical, how it's done. And that's what I think the MBA ought to do. Sit down with the Council of Legal Education. How can you make the curriculum more practical? Tell people how to draft motions, how to draft pleadings. Not be telling them that order 10 is this, order 10 is that. When they go to court, order 10 is in the rules of court. They will see it there. But be more practical in the curriculum. That's what the MBA needs to be doing. Thank you.
Sorry. Sorry. Okay, so I'm sorry. I have to come back to the three aspirants. Before then, I'll just one or two questions to one question for the other three to answer. Then I'll come back to the three aspirants. Okay. So what I take away. So, Dr. Rapolo Unduka, so what I'm going to do is I'll ask a question, and then as soon as you answer that question, once you answer the question, hello? Okay, so I'm going to ask you a question. So, law teachers, I'm glad you're a law teacher, even though the others are not. Law teachers are critical members of the bar, but face severe welfare challenges, contributing to brain drain. What concrete financial or institutional support mechanism can an MBA-led law teachers research welfare endowment fund be able to do to improve the condition of service and research capacity of NALT members?
Thank you, ladies and gentlemen. First of all, let me just point out that I am consulting for the Office of the General Secretary. And one of the things that we'll be doing is to keep talking and keep asking and requesting that things be changed. Now, one of the things that I noticed that whenever I talk with members of NALT, I've gone outside, I spoke with a number of members of NALT, and one of the first things I hear is that they keep telling me that they're not interested in what is going on in the MBA. And I remind them that that kind of decision that you want to happen or for the MBA to push for you cannot happen when you sit on the sidelines and only criticize. We must be part of what is going on in the MBA. If we are not part of it, all we can end up doing is to keep complaining and things will not change. Now, talking about the welfare, remuneration and all. Now, there are 4 things that we must always remember. Number one is that law teachers are not properly paid. The remuneration is poor. There's limited access to research grants and publication of funds. And you know that as a law teacher, you are expected, in fact, the slogan is publish or die. And so, most of the time...
Sorry, distinguished participants, let's pay attention to the conversation. Thank you. If you can bring down your voices, please. Thank you. Please go on.
So the law teacher is expected to keep publishing, and yet he is strapped of funds to make sure that those publications are always done. It's a problem. You also have the lack of institutional recognition within the MBA structure, where the MBA does not recognize law teachers in the mainstream of what goes on in the MBA. And also we have brain drain. Most of my colleagues have left for Canada and the United States of America in some few years back, because as far as they are concerned, whatever they are taking home does not help them. And so they keep moving. And so we must look inwards to deal with this issue. Now, so 2 things I would like to point out. Number one is this. MBA has spoken for the police. MBA has advocated that the police be better remunerated. MBA should also speak for law teachers. MBA has spoken for the judiciary. Now the judges are paid at least 300% of what they used to be paid for. MBA can also speak for the law teachers to be paid better than their counterparts in other departments. That is what MBA should do. And if God helps me to go there, I'll be pushing for some of these things. Now, I would also advocate
Thank you, Dr. Rappo. We'll go to Mr. Yakubu. Same question. Me to ask you another question. Okay, let me ask you another question. You want to deal with this? What would you like? Another question? Okay, good. Okay, so to bridge the gap between the town and gown, what program can you initiate, facilitate structured sabbatical opportunity for law teachers in high capacity law firms or judicial departments? That's the question.
Okay, thank you very much. You know, one of the things with MBA as an association is that the offices are all structured and centered around the office of the president. So the first thing I must tell you is that you must be conscious and highly interested on who become or who you will give your mandate in the next coming election. Number two, in the aspects of how we can assist the law teachers, we must know that MBA is an association. And as an association, the association has a duty to cater for their members. And of course, law teachers are also members of Nigeria Bar Association. So just as the MBA has advocated that the issue of Sikh, there should be no discrimination between the law teachers and the private legal practitioners and those in public offices. They can also advocate for an improved remuneration of law teachers. And the law teachers themselves, which I happen to be one, we must explore that aspect of Nigerian labor law and look at the Labor Act and activate the provision of the Constitution that is made to be non-justiciable. That is to say, there should be no discrimination in respect of payment of salaries or wages or remuneration. That if one who works in CBN takes ₦1 million as a monthly wages, a law teacher is also entitled for ₦1 million. And we can activate that aspect of law by filing suit as an association, MBA as a body, so that what is being practiced in Pakistan and India, where their chapter 2 of their constitution is interpreted in such a way that gives life, the chapter 4 now gives life to their chapter 2. That aspect of law will be given flesh and blood. Thank you so much.
Thank you. Thank you. Just pass the mic to the next aspirant. Okay, so you can respond to the same question.
All right. To start with, to my erudite scholars, professors, I'm running for, or I'm consulting for the position of Publicity Secretary of MBA next year. The election is going to be in July, if God grants us life. So now, with regards to our role as law teachers, I know as a fact that being a member of NALT, law teachers have great influence on the activities of the MBA. But the only thing is that law teachers have not taken their rightful position in participating in the activities of the MBA. While I was branch chairman, I remember that I have to go to the Faculty of Law of Nasarawa State University, Kefi, to mobilize the law teachers to come for Congress meetings. Because there are times that some of the resolutions of the MBA goes down to the branches. It's from the branches that sometimes it generates some of these decisions. So if you are not at the meeting at the branch, you won't be able to influence it. If you are not a member of NEC, it will be difficult for you to influence. And then, also, our active participation, because the truth is this, if you are not within the corridor of power, certainly decisions will be taken against your interests. Now, moving forward, as per the welfare of the members of NALT, I just came back from Ghana for the AFBAR conference. This is the African Bar Conference. And I wasn't just there for the purpose of that conference alone. My interaction with lecturers in Ghana, particularly the ones that I interacted with, the law school lecturers, that once you are a senior lecturer in Ghana in their law school, your salary is at the same as a high court judge in Ghana. If you are now, let's say, an associate prof, then your salary is the same as a justice of the Court of Appeal there in Ghana. Ghana is in Africa. Is that not so? Now, moving forward, once you are a prof, you take the salary of a justice of the Supreme Court of Ghana. And that is what is obtained there. So why can't we do it and replicate them down home to see how we can make sure we bring things down? But then the issue is this. Most of these things, we don't actually to go. Now, the Senate President himself is a lawyer. We can now constitute a committee of NALT to go and have this constructive engagement with the intention of influencing whatever that will bring about the betterment of our welfare.
So thank
because
you.
If we don't do that, certainly,
Dr.
it won't be
Yakubu.
of any help to us.
Thank you.
So thank you. So, and then going forward, just one moment, sir. Just a minute. Is that as an association, once the opportunity is given to as an image maker of the association, which is MBA, we will make sure that we speak for both the law and the MBA at large. Thank you so much.
All right, thank you. At least the example you gave of Ghana is very encouraging. Most of our members are quite inspired by that example. It is what we'll see. At this point in time, I'd like to thank Dr. Yakubu, Dr. Nuhu, Dr. Unduka. My focus will now be on Mr. Latif, Professor Foluke Dada Lawansin, and Mrs. Badejo. More importantly, because Dr. Nuhu said that within the office, the three of them are aspiring for. So what I would like you to do, if you can pass the mic, it's thoughts on 1, MCPD, 2, integration of AI into legal education, 3, quality of output, quality of legal education, and the output from the law school. So those were the 3 questions I asked individually. Now you can bear your thoughts on all 3 so that the participants can evaluate you and assess you on the same basis. Thank you.
You know, sitting here, I've noticed one thing. Every time somebody that describes themselves as a law teacher or has something to do with law teaching picks up the microphone, the decibel goes down. So you lean more towards the people that you recognize. So let me give you something to recognize me too. My father was a professor of surgery. My mother was a university administrator. In fact, she became the first female registrar of University of Lagos. Whether I'm adopted or not, I'm in the family. I spent my entire life before I got married on University of Lagos campus. First on College of Medicine Idiaraba campus, then University of Lagos. My sister was teaching at the Faculty of Law in Unilag before she went to become a government worker. I'm talking about Dr. Jumoke Oduole. And she still has plans, although now I think, oh, she was your classmate, okay. So she was teaching law at the Faculty of Law Unilag before she left. I understand that now, probably she spent too much time outside. She probably can't go back. But she will definitely continue to teach law in an informal capacity because she loves teaching law. But so that's the background I have. And you know, I just wanted to, because I already spoke about the AI thing, I just wanted to talk about the MCPD, because my understanding of the question was, how can law teachers also take advantage and have subsidized training. I grew up seeing my father go on study leave for 1 whole year to the United States, all expenses paid, and on sabbatical. And at a point in time, he was a Fulbright scholar. Now, I cannot conceive a world in which people who teach are not able to access funds that will enable them to do research, to write the books that enable us to learn the law, to go on study leaves and all that. So I like practical solutions, implementable things. We have many foundations in the world whose responsibility is to help to make the world a better place for people like you. I see no reason why an MBA will not actively engage a MacArthur Foundation, for example, for the sole purpose of providing grants for law teachers to do research, to go and do sabbaticals outside of Nigeria, even on the African continent. Professor Ojedoku is here from Protestant University of Rwanda. I'm sure there are things that we can learn from that university. I'm sure there are things that people from there can learn from it. So I think that the first starting point, the MCPD as it is currently constituted, is very much geared towards legal practitioners. We have to have a CLE that is specific for teachers, like Train the Trainers. Train the Trainers programs are totally different from Train the Students. So we need, for law teachers, unfortunately, we just have to get involved. I know the MBA has a responsibility to look after law teachers, but law teachers must also pay attention. Because my people have a saying, I bow simbel, I bow dasi. You have to get involved because you are the ones that know where the shoe is pinching. And so that the ideas on how best to help law teachers train the future will come from you, and with that cross-fertilization, we will begin to see better results. Thank you very much. Aren't you going to clap for me because because Professor Dada says I'm adopted? I'm not adopted, I'm in the family.
You're still adopted, whether you're well, I won't say imposing yourself, but we welcome you. We have large hearts here. Okay. But I remember very vividly your father, Professor Lumide. So that is, he was a very great professional, a great teacher. So, answering the question, I just want to say that I will come from the point of a teacher who has been there, who has seen it, growing from the lower cadre up to the professorial cadre. I remember vividly that I had to go through a lot to attend conferences locally and internationally. And in doing that, we had to spend our own monies. You needed to encourage yourself. It was either publish or perish. And you needed to do so much at the level, especially when you're getting to the level of senior lecturer up. So I think the NBA would really want to help our colleagues in the academia. And I want to encourage our colleagues to ensure that we participate at the bar. I think our participation is where the problem is. In the years past, and when I started teaching, I didn't have the encouragement. Nobody told me what to do, but I had practitioners, private practitioners, who encouraged me to participate at the bar. And that's how I became the vice chairman of Ado-Ekiti branch. I became the chair of Ado-Ekiti branch. I became the second vice president of the bar, and I'm currently the chair of the Lawyers and Academia Forum that we have now decided to change to the Academic Forum in line with the provisions of the Constitution of the bar. But why did I say this? Or what am I saying it? I'm saying it because it is very important for us as teachers to participate so that we know what is going on. We complain about the fact that we have just one SAN every year, but Who's responsible for that? Were we at the table where the decision was taken? No. So please, let us move NALT, the power of NALT, into the MBA academic forum, and let us sit at the table and decide on important issues. However, I also want to say something about what my sister here said about training. And I agree that the MBA should make sure that NALT members, teachers generally, are encouraged. We should advocate for law teachers to get important grants, local grants and international grants. And I do know that MBA has the MacArthur Foundation grant, and they have other grants that they can access from the British Commonwealth and all of that. But it is for us as teachers to ask for these opportunities so that we get
Can we
ETF.
please listen?
Yeah, we get ETF from the federal universities and the state universities. Private universities don't get such grants. But we can do a lot more as NBA by ensuring that specific grants are requested for.
We should give. Yes, Mr. Latif.
Yes, thank you very much. Well, just like Mrs. Bado just said, I'm not an academic. All I do is I teach arbitration. I'm a member of a faculty that teaches arbitration. I don't think that's enough to call myself an academic. So I'm a practitioner. Well, to go to the question, you see, I want to talk not like a politician. You know, Nigerian politicians will talk to you. A state government, a candidate for the gubernatorial office will tell you that he will give you electricity, he will give you this, he will give you that. And people don't even think that is even within your remit. Can you sit on electrical matters? Is it part of a state matter? But they just say it. Now, I'm going to talk to you sincerely. And I'm going to say that the NBA, if you look strictly at the objectives of the NBA and its constitution, NBA, the constitution says to ensure, training of practitioners, lawyers, and retraining of lawyers. Speak for the judiciary, the court system. They defend the human right, rule of law, protection, preservation, and all of that. So if NBA goes strictly according to its objectives in the Constitution, it will not say, oh, now I want to train out and let now be part of my curriculum. They're not going to say that. They're going to tell you my core remit is practitioners. But the problem is this, and this is the issue. We need to go beyond that. The NBA has to be intentional and ensure that NALT members is brought into the core MBA. And NALT also has to be intentional to make sure that, for instance, they're running for offices in the MBA, NALT members should be part of the EXCO. And that's the way MBA can get to know the pain point of NALT members. Now, being here today is also an opportunity for me to interact and know the pain points of NALT members. I, for one, I'm one of the people that have kicked against, I'm just giving an example of saying that only one academic can become SAN in a year. But yes, but MBA is not part of privileges committee. It's not part of it. There's nothing the MBA president can do other than through advocacy. But I believe that through the advocacy, if we know and the right people are there to push these things, we can get them right. But if you don't have someone that understands what the pain point of NALT is, what the pain points of other sectors are within the profession, whenever you're just going to pay lip service. Now, talking about training, I'm one of the people that say that even training that the MBA is trying to do, they're still grappling with that training. They're not doing it properly. Now, you see lawyers now running around for CPD points.
So thank you,
because
Mr.
of, sorry,
Latif.
one minute. Because of the fact that they know there's fear of sanction if you don't get your CPD points. So by next year, if everyone here does not have they have 5 CPD points, they may not renew your license for you. That is what's happening at the moment. But this CPD point, if it's about training, learning and retraining of people, it has to be value-driven. Law teachers must see the value in going for those trainings. I must see the value in it. Otherwise, all I'm going to do is, when I see a training going on, I'll log on and I'll go and do something else, just to get my 5 CPD points. And once I have it, I switch off. Now,
Thank you.
We can't have a system like that.
Thank you, Mr. Latif. Thank you. So one common point from the three aspirants is the necessity and importance for NALT members to be fully involved in the activities of the Nigerian Bar Association. And that underscores the point that was made by Winnie Mandela some years back when she came to attend a program in Nigeria. She said, "Nothing about us without us." So, NALT members, nothing about us without us getting involved in the Nigerian Bar Association. So thank you so much for that point. I'll come back to you for your passing shots, but I'm going to start with Dr. Yakubu in 60 seconds so that we can give the audience opportunity to ask questions and interact with you. 60 seconds, your passing shots.
Thank you so much. I would say it's important that we get involved and also participate actively, because without our participation, decisions will be taken against our own interest. And until you are there, you won't be able to have your voice, to have your say, or to have your way. Until you have a voice, you have a say, before eventually you will have your way. Thank you so much.
Thank you.
As the chairman of Citizens Liberties Committee, I will be proud to say that I have come to the aid of many, or the committee have come to the aid of many members of NALT. I will give an example with one of our colleagues who was who the DSS boggled his apartment, picked him from base university quarters, and then took him to Sokoto, detained him. The Citizens Liberties Committee of National MBA, with zero allocation from the association, took that matter up and ensured that he was timeously released. Many examples. I can bet you that my desire to serve you as a second vice president is born out of the fact that there are so many human rights abuses out there.
Thank you.
Not only within you, within MBA, but with the ordinary citizens. Thank you so much.
Dr. Unduka, 60 seconds.
Thank you so much. Just my parting shot is that we cannot keep complaining. I'm a member of NALT, and one of the reasons why I keep pushing is that I can sit in places and I can get your complaints and speak about it and try to make a change. The essence of us as lawyers is that we create social change wherever we are. And if we don't understand that, we'll sit on the sidelines and keep complaining. It is time that we get into the center of what is going on so that we stop complaining and start creating some change inside of MBA. Thank you so much.
Thank you. Mr. Latif?
Yes, thank you. I'm going to wrap up by saying that in life, we get the leaders that we deserve. If I know the system, and I know that the profession has gone to the dogs right now. The system, everything, ethics, value, we've lost it. But who are we to blame? At the end of the day, the leaders that get there every 2 years, how do they get there? The problem of the MBA goes beyond rhetorics. They go beyond relationships or gender considerations. The issues are very clear. Who can fix them? Interrogate the people. Interrogate what they've done before, what they want to do. How many people saw the manifestos of the current president and his co-contenders at the time they were contesting? How many people read their manifestos to know who to vote for? How many people check their track record to know what they are going to do? Where you're coming from is important in determining where you're going to.
Thank you.
We know them.
Mr.
We don't
Latif.
know them.
Thank you.
Thank you very much.
Prof?
Okay, my 60 seconds starts. I want to start by saying that my decision...
Speaking to the mic.
Okay. My decision to present myself again for service by aspiring to become the next and the first democratically elected president of the Nigerian Bar Association is born out of my experiences as an academic person. I have been through the process, I've been through the ropes, I've served, I've learned through the ropes, and I can confidently tell you that it is not even about gender. It is about capacity. It is about competence, competence, competence. Do we have that competence as law teachers to lead the bar? Yes, we do. And if we don't do it, if we don't stand up and take up the duty, the responsibility to lead the bar and ensure that the interests of law teachers are taken into consideration, then we will just be complaining for nothing. With every good leadership comes good followership. I appeal to you, I am one of you. I am one of you, and I want you to give me that chance. Check my background, check my records. I have served, and I can represent you well. And this is my final words. Please remember it and take it to heart. Thank you. It's a mission we all have to fulfill.
Thank you, Prof. Thank you, Prof.
Thank you.
Thank you. Mrs. Balijo, senior advocate.
So I'm adopted. And
okay.
aside from being adopted, I don't have the background. I haven't held the offices they've held. All I'm bringing to the table is passion. Everything that I've achieved in life is because I'm a lawyer. And the reason I'm a lawyer is because of you. So I have a great, yes, you can clap. You can. Because I have a great regard for teachers. But anybody can come here and say what you want to hear. What I am about is not making rash promises. But I believe in collaboration in order to develop sustainable solutions. And that can only happen when you and the MBA come together, identify the problems, and identify the solutions. And that is what I will bring to the table. Thank you very much.
Thank you, Mrs. Badejo. Okay, so earlier on, Chief Afam Okeke was here. He had to leave to attend to a health emergency. He sent in his apology. As we're rounding up, one of the aspirants came in person of Are Muyiwa Akimboro, Senior Advocate of Nigeria. Since we're having passing shots, I'll give him the opportunity, but we'll extend his own passing shots to 2 minutes and not 60 seconds. Are Muyiwa Akimboro.
Thank you very much, Mr. Moderator. Our teachers, good afternoon, everybody. I want to start by first apologizing for coming to this event late. It's not out of disrespect. I was away in some areas because I don't want to leak my secret to I was away somewhere. I had to come in this afternoon flight and rush home to freshen up, to look good before you. I am starting here today solely because of all of you. And I believe that the association that deserves the most respect is the one that builds. All of us here, we are here because of you. So I want to say thank you for taking us to this level. I don't know, I've heard a lot of things being said, but I know that it's not yet time for campaign for the presidency of the bar. And I don't think it's proper to start campaigning on what I will do or what I will not do, because it will, at the end of the day, be running against our laws. And this is law gathering, and we must respect our laws. But I can only tell you what I have done before. I've served you in several capacities. I've been secretary of a branch. I've been chairman of a branch. I've been general secretary. I have served on the FTT GSE. I've served on the AGSE. I'm a life bencher. I have served on the council of a university, University of Benin. I have served on the Leka Practitioner Disciplinary Committee, and I've also served you. I've served you almost in a lot of capacities. And if I want to start leading to my CV, the 2 minutes will not be enough. All I have to tell you is that I will not come. I'm trying to talk to you now about my intention. And my intention is not going to land on a job. So I'm coming with cognate experience that will suit the bar. There's some things that are worrying me. I look at the topic, and I saw the depth of the topic chosen. It spoke about globalization, development, and national development, economic development, and also national development. If you take it upside down, it speaks to our mindset that we should open our hearts and be global in our outlook. There is no way that if you look at that topic, it will trickle down and have a trickle-down effect to the foundation, which is national development. And one thing I want to tell you is that the materials that took us to the level that we are today, like I said, I'm a senior advocate of Nigeria. I believe I learned, and it was something that came from your knowledge. So what I can say is that I feel pained when I saw that the elevation to the status of senior advocate for academics is now limited. But I can say, and I'll tell you that God's willing and our prayers being answered, there will be equal level playing field for everybody.
Thank you, Are. Thank you so much. We were actually taking a passing shot when you came in because time is fast spent. We appreciate your presence. We accept your apology. We have listened to you, and I'm sure my people have heard you. So thank you so much.
Thank you.
Ordinarily, yes. Okay, I would like to take just 2 questions, one male, one female. I'll take the man in front. More questions? You see, I've just been reminded that we have another plenary for today. And my dean, chairman, a number of people who would like to ask questions. What do we do? Okay, so our numbers, and I like to be gender sensitive. So I'm going to do 1, 2, 4. So 5. Please, can
Good afternoon, everybody. I am Professor Agbo Jeremiah Johnson Mada from Federal University of Lokoja. And I welcome all the aspirants to various offices of the MBA. Yes, I'm going to go straight to the point. If Are had not spoken on the issue, the vexed issue of conferment of SAM on lawyers, it was the issue I was going to raise. And it is a good thing that you have speaking well-informed advantage position. I know too well that at particular meetings of the Legal Practitioner Privileges Committee is senior advocates like you that argue very vigorously while people in the academic should not even be in any slot at all. This I know too well. And the argument persuasive. And I don't want to say that the then CJN of this country was simply reroded into accepting the stand of the majority. It was nothing but the tyrant of the majority. Having said that, as a very, very active member of the bar, and a lot of you know it, for the last 40 years, the position of the office of the MBA over the years has become so powerful that the president can literally sign a death warrant and it will be carried out. So I want to urge whoever becomes the president of the NBA, that let it not be mere campaign rhetoric. When you get to that office, for fairness and equity and justice, the NBA president is in good stand and in good position to actually alter the position to ensure that the rank of senior advocate of Nigeria, which is a privilege, will be equally of new terror extended to people in academics without discrimination. Thank you very much.
Thank you very much. Yes, I'll just the question. Yes, you see, NALT exists within the polity Nigeria. And if this country is not doing well, there's no way NALT will do well. Now, the weakest institution in this country today is the judiciary. And because the judiciary is weak and in a captured state, that has enabled executive lawlessness, legislative lawlessness, and even judicial lawlessness. Now, your NBA led, you leading the NBA now, what would you do to stir this sleeping giant to become the true watchdog of the people's right? Thank you.
Yeah, my question is simple. President of the to limit, to restrict the number of law newbies that are leaving this.
Number 4 is the lady. So number 5 is also a lady, and that's all.
Good afternoon, and thanks for the opportunity. My name is Osama Izora, based in University, Abuja. I'm actually asking this question on behalf of Professor Evis Obi, who is griping about the way law teachers are treated. She thinks that all of you here are here because this is a captive audience. Yes, for the election, because everybody here is a lawyer. And if you got all of NALT voting for you, you've got quite a cache of votes. So, is it just a marketing place where you come and play, or do you actually have intentions of making NALT a more acknowledged body in Nigeria?
Thank you. So the last person, the lady behind, please can you help me pass the microphone to the lady behind?
Hello, good afternoon all. Part of what I intended to say has been said because it has to do with, okay, so I am Dr. Elizabeth Yamojo from University of Benin. Part of what I wanted to say has been said by some of the other commentators as regards the privilege of SAN and the discriminatory attitude of the Legal Practitioners Privileges Committee. And I'm wondering, MBA is the father of all the committees. And I'm wondering, why is MBA silent? I want to see all the persons here today as representatives of the MBA. So they've been silent about this, and
thank you.
No, sir, please.
So round up.
From the Regulations and Other Professions Act of 1978 was the first act that kind of prohibited law lecturers from practicing law. While it did that, there was an exemption. After the exemption, there was a subsequent abrogation of all laws by the military, which ensured that we were status quo. We couldn't now practice. Although we have a decision that says that now it is
Thank you. I believe the aspirants have heard you. So I'll give them 60 seconds to respond.
Yeah, consider to me. Yes. So to answer the first question, you know I'd said to you before that it goes beyond rhetorics. I know for a fact, and I can tell you that the NBA president does not sit on the privileges committee. If anybody tells you here that the NBA president sits on the privileges committee, is lying to you. However, through advocacy, NBA president can get the buy-in of BOSAN, BOB, and collectively make a representation before the CJN, who is the chair of the committee, and revise this issue and look into it. That's the thing we can do. And I know for a fact that it's something that it ought to be done. It's unheard of.
Thank you.
People that produce.
Thank you, Mr. Latif.
That's the first question.
No, that's okay.
No, that's it.
Let others take the other ones. We don't have time.
Let me talk
There's
to
another plenary. Thank you, sir.
Brother Gomes, you talk about institutions. We have weak institutions in Nigeria. The NBA is a very weak institution as it currently is. I say that to you. Now, everybody keeps talking about the presidency of Alawa Kabashorun. Now, do we have presidents like Alawa Kabashorun today? Do we have fearless people? Alawa Kabashorun is one president that refused to go to meet IBB. Today, what do we have? We have NBA presidents who we are so happy to go and meet the governors, to hold meetings with them, and all of that. How do they respect us?
Mr. Latif.
You need a fearless person to be in that office and give respect to that office of presidency. Currently, we don't have that.
Thank you very much.
Thank you very much. I think we need to elect the president that will represent us well. We should not elect or vote for anybody who we're not sure of. Simple. The NBA president holds substantial powers to do and undo at the bar. Let us first of all look at the constitution of the NBA. Is there anything we can moderate? Is there a way we can restructure even from the inside before we start complaining about what they are doing? But let me tell you for a fact, until we get to that situation or position where we are speaking up as members of NALT, representing our own interests, nobody will fight for us. We're not here. I personally am not here because I am looking for your vote. I am part of you. And I think it is reasonable for you to want to ensure that you are represented well.
Thank you, Prof.
Look at our antecedents. Okay.
I am here because I'm looking for your votes. Because I cannot ignore such a captive order. Prof, anybody that tells you differently is not telling you the truth.
I am telling the truth.
Okay, ma. They know you already. Okay. And you know I'm adopted. So I have to come back. So many of you don't know that I'm an adopted child. On a very serious note. This, indeed, is a captive audience. And anybody who is serious-minded about what they want to do will come to a gathering like this. Because we want you to know us. I want you to know me, to hear me, to assess me, to decide for yourselves. I have no power to compel everybody in this association to vote for me. The only thing I can do is talk and show myself and leave you to make an informed decision. And that's what I've come here to do. Now, aside from that, I want to believe that NALT exists, just like the NBA exists for the welfare of its members. NALT exists primarily for the welfare of law teachers. And so, Prof, let me ask. You said many of the senior advocates in the LPPC were the most vociferous arguing against law teachers taking silk, and that their arguments were not persuasive. Are the counter-arguments on the table? Prof, President, where is NALT's position on this issue? Where are the persuasive arguments that have been presented to the LPPC? Because I believe that there are arguments in favor, even if it means we don't have to throw away the baby.
Thank you.
Sorry,
Thank you.
just give me 1 minute because you
No,
gave
no,
everybody
not 1 minute.
Even if it means
20 seconds.
Even if it means tweaking things so that the requirements, maybe people feel that the requirements are not stringent enough, tweak the requirement, but don't throw away the baby with the bathwater. But it has to come from somewhere, Prof. We have to design a system whereby NALT will gather the views of the members.
Thank you. 20 seconds.
Send them in the appropriate places.
Thank you.
That is what I think NALT should do, and that is what I think you can partner with the NBA to do.
Okay,
Thank you
back,
very much.
Back to my Egmont, Are Muiwa Akimboro.
Thank you very much. I will try my best to answer the question in 60 minutes.
In 60 seconds.
On 60 seconds, sorry.
Hour.
On the first question about senior advocate of Nigeria, I want to say that I understand with my friends, they don't know the power of the president of NBA. That's why they can speak like that. Electing me as your president, I will use the good office of the president of NBA to make sure that I get for NALT what they deserve when it comes to sanctionship.
Thank you.
When you talk about, when you are talking about issues of lawyers.
Please, can we listen to the aspirants? We asked them to come and interact with us, and we're having this conversation because of burning topical issues. Yes, please go.
I hope that does not count in my time. There's a question on judiciary, new wigs, acknowledgement of NALT. I want to tell you something that I believe strongly. The best hands are in the academics. Anybody that wants to succeed, we know that you need to get the right people to assist you in office. You need to put the right pegs in the right hole. Not for me, are supposed to be running our ICLE. So I already have a place for NALT in the admission of the MBA. You professors, all of you will come. I know the system, and I know that I need you in running our ICLE. When you talk about, all the other issues I'm talking about is about welfare. No association that is worth its salt will play with the welfare of its members. I want to tell you one mistake that everybody is making. When they talk about lawyers, they think lawyers only mean lawyers in private practice. No. We owe responsibility to every lawyer. We all pay our practicing dues.
Absolutely.
And we serve NALT. You are paying your practicing dues, you are entitled to the same treatment with lawyers who are in private practice. And that is my promise.
Thank you, Are Muiwa Akiboro. Thank you very much. So we've come to an end. Every good thing must come to an end. So we've come to an end of this plenary session. I'd like to apologize to the next plenary, particularly my friend, Professor Abikon, for the delay, but you can understand why this took so long. Interestingly, those who argued against academics being conferred with the rank of senior advocates are now taking up, through whatever does, professorial title. So a lot of them now bear professorial, even though their name is not in the NUC database. We know, so we know ourselves. So thank you very much. On this note, I'd like to invite the chairman organizing committee, Professor Celestine Wakwe Abugu, to give a vote of thanks to the panelists while we also take the panel photograph. The president, the chairman, BOT, please join these panelists for the group photograph.
Thank you.
Ladies and gentlemen, we'll be going to the second plenary session immediately. We'll be asking that we please be seated so that we can just go into the second plenary. But I'll be handing over to the LOC for some housekeeping announcements before we go into the second plenary. Thank you so much.
Okay, hello? Hello? Can you hear me? Good evening, our wonderful conferees. We hope you're enjoying yourselves so far. By way of housekeeping, this is our announcements because you can see that some people are just trickling out one by one, and it's important that you get this information. So this evening, we're going to have the evening night out, social nights, casual and relaxation nights at Toxi Hotel, Gwagwalada, for those who are mobile, those that have their cars. For those who don't have their cars, if you are at the Asu Chalet, a bus will convey you by 7 p.m. to the venue. And at the end of the event, we'll bring you back. For those in other hotels, vehicles are made available to convey you to the Friendship Heights at Gwagwalada. Then for tomorrow morning, the buses will come back to pick you up from your various hotels at 6 a.m. for the health work. We're going to have health work. So we'll now converge at the Faculty of Law mini campus, the old campus before we got here. So we'll converge there and begin to walk from there in Gwagwalada. Okay? So please get ready tomorrow morning for us to take this health walk. It's important, okay, before we now come back here. So the vehicles will come and take us by 6 a.m. to take us there. The health walk begins by 6:30. Thank you very much.
Yeah, good afternoon, everyone. Your Minister of Transportation. Please, we want to ensure everyone enjoying the transportation system, that all the issues we experience, we don't experience it again. In order to do that, this is how we are going to arrange for the transportation. Those who are from particular hotel, kindly identify and then meet with me. We'll be able to attach you to a vehicle that will convey you. And that any vehicle we attach you to, you get the driver's number. That will be the vehicle that will convey you tomorrow. And that will be your permanent vehicle that will be conveying you to this conference and be returning you back. Because you know this is a conference like no other. So we want to ensure that you have very good experience. You know, thank you very much. I don't know how many of you have attended any conference where they attach you to vehicle. But we are going to do that. We have military vehicle, we have civilian vehicle. So this is how we're going to do. Please, kindly ensure you meet with me, and then we'll be able to tag you with a particular vehicle. If we don't do that, please don't blame us. You know, we have so many people and we need to manage the situation very well. If this is done, by tomorrow, you don't need to call anybody again to transport yourself from your location to where you are going, because any bus we attach you to now will be the one that will pick you and return you back. I want to appreciate you. Thank you very much, and God bless.
Thank you so much. Thank you so much. We'll be going to the second plenary session, and the topic of the discussion is rejigging the jurisprudence of election petition in Nigeria for national integration and cohesion. And every one of us would agree with me that our jurisprudence for election petition is something that needs to be touched. Most people argue that the INEC should have they should have the burden to prove that every election that they've done is done well, and not the person challenging the election. And today we are discussing the rejigging the jurisprudence of election petition in Nigeria for national integration and cohesion. And to discuss this paper, we'll be calling on, first of all, the chairperson of this plenary session, Professor Ibrahim Abikon. Can you please put your hands together for him as he makes his way? He is the Director General of the Nigerian Institute of Advanced Legal Studies. Thank you so much, Mr. Chairperson. And to also assist him is Professor Emil Ifejola Alemika. Please, a round of applause for her as she makes her way to the stage for this wonderful discussion. And to also, I've been told or informed that the Professor Emily is the presenter of the paper herself. So please, a wonderful round of applause for her as she makes her way to this podium for the discussion. We also have, can we also have representatives from the Federal University, Lokoja? Also, we need a representative from the Bayero University, Kanu. And also to discuss the paper, we also need a representative of Benson Idahosa University. Please make your way to the stage. And also to discuss this paper, we need a representative of Al Hikmah University. Please, a round of applause for them as they make their way up to this place for this paper or this plenary session. I will now be handing over immediately because this session just has 45 minutes alone to discuss and to present the paper and to discuss. So I'll be handing over to the chairperson, Professor Ibrahim Abiko, to direct the plenary session. Thank you so much.
Thank you. A very good afternoon to our distinguished scholars, professors, senior advocates of Nigeria. It's been a very long day for all of us, and we'll be running this session under 1 hour, God willing. And I believe it's going to be very fruitful and interactive. We already have, please sit down. We have 3 faculties discussing. Once again, my name is Professor Abdulkadir Ibrahim Abikan, the DG Nigerian Institute of Advanced Legal Studies and a former president of NALT. We have our eminent professor to present the lead paper for this session, that is rejigging the jurisprudence of election petition in Nigeria for national integration and cohesion. And to present this lead paper is no other person than our own Professor Emily Ifejola Alemeka, who has a lot of caps on her head, or a lot of hats on her head. She was formerly of University of Jos before she moved to the Nigerian Institute of Advanced Legal Studies. And I'm aware that she's on loan to Federal University Lokoja as the founding dean, is the pioneer dean of the Dean of Law, Federal University Lokoja. We also have on the panel to discuss the paper, Dean of the, Bayero University Kano. Do we have the representative of Bayero University Kano here? Please take the front seat, please. Yes. Bayero University Kano, you know, our presentation and discussion are faculty-based. So they are not individuals. Those individuals we are mentioning their name are only representing their faculty, whether as presenters or as discussants. So the discussants will be mentioning their name by the time they are making their presentation. We also have as discussant the representative of Benson Idahosa University. Where is he, please? Benson Idahosa University is not here. And we have, lastly, the representative of Al Hikmah University, so that I will not be taken to be biased as introducing the personality of the representative of Al Hikmah University. I will also allow him to introduce himself by the time he's making his presentation. Now, this is how it's going to run.
Please, can we have a session, please? Those our colleagues at the back, please, let's have a session, please. This is what we are here for. Thank you. We are going to take 20 minutes for the lead presentation and 10 minutes for the discussants. We are all lecturers. We know how to summarize our notes or whatever we have prepared and just speak to whatever we have prepared so that we give time for the audience to also be able to contribute. So, we start with the lead paper presentation. Our own Professor Alemeka, I must also mention that she has consistently been the chairperson of our uniform NALT law guide. We all have it in our conference materials. She has been the chairperson since 2013 in Ilorin, and we have been reviewing that, and we thank you for doing a very good job on our NALT reference guide. So we give you 20 minutes to make your presentation. Thank you.
Distinguished chairman, who double to also be my boss, our distinguished professors, the SAN here present, and our invited guests. Ladies and gentlemen, this paper was initially slated for sessional discussion. And when I got the paper rejigging the jurisprudence of election petition in Nigeria for national integration and cohesion, the first thing that came to my mind was that how can we limit a paper like this to just a sessional? For a situation, I mean the current situation as regard election and election petition in the country. More so that in the recent time, the electoral act is being under review. I think it has passed the second reading with the constitution and the rest of them, getting to be reviewed. I thought that, as teachers, we have much to say, to speak to this topic. But as God will have it as usual, for me, it's not surprising to me when now the same way I was thinking that the right thing would have been to speak to this topic, at the plenary session rather than being just a sessional paper. We are babies. We're just about 4 months old. And so, but let me tell you, the people behind the scene that are beating the drum, they dictate the tune, and we have been dancing, and within a year plus, we were able to get both the NUC accreditation, followed by CLE, and for which, the chairman of this occasion is part of it. And then, as I told you in the morning, the INEC chairman was a consultant visiting professor, and of course, we have other people, ably representing the faculty. And so when the issue now came up, I was so happy for two things. The topic is contemporary, and again, our own federal university is also a baby university that need to fly. So what we have done to this, I'm just going to take a general review so that we speak to the topic. So we look at it that to talk about the election petition, it's so suggest sit down and then we look at it that when we look at election petition, where is the problem coming from? What is the foundation? And if we don't speak to the foundation, we probably will not be able to get far from being able to rejig, reposition, reconfigure, and also overhaul the election petition. And so what we have done is to divide our paper into about 3-4 parts, starting with the introduction, and then we also look at the foundation, which is very, very germane. The foundation of election petition. Please, I want us to listen, because we are going to make contribution. I've told you, that is the trend. And if if we are going for national integration, and then what we have been going through with respect to election and then the election petition, then please, we need to listen, because we are not presenting this as academic paper, but a serious thing to look at, and then you make your own contribution as to how we can take this country forward. And so please lend me your ears. And so what we have done now, we look at you are still talking when I'm talk, you are talking. So please, so we talk about the legal and institutional framework that deal with the election and then election petition. A critical look suggests that even from the foundation, from the roots, please, can I get water? So, we look at it and say that, critically looking at it, the foundation of our election process in Nigeria is wrong from day one. The first republic was characterized by coup. The second one, thank you. Even the third republic that was said to be the best, not really our best. And so, that we have already prepared before we plenary session. They are going to speak to the institutional work. We move to the comparative analysis, and then discover that the election itself is plagued with so many problems, including all the irregularity that characterize election in the country, vote buying, ballot snatching, and the rest of them. And we discovered that except we address the election process itself, we may not be able to. Thank you. We will not be able to reposition the election petition. And so, on that basis, our leader, the legal and critically look through the legal and institution framework, and then we look at the analysis, then we move to all the problem that is associated. We talk to it shortly, and then of course we come up with a recommendation and proposal. Thank you. On this note, I'm going to call on Ibukun to speak briefly to this problem, so that we'll be able to reposition election petition for national integration and cohesion. Thank you very much.
Good afternoon, Chairman. You please permit me to stand on the existing protocol because of our time frame. You agree with me here that Nigeria is blessed with both legal and institutional framework. Okay. You agree with me that Nigeria is blessed with both legal and institutional framework for elections and election petitions arising therefrom. However, every electoral year is fraught with irregularities, dissatisfaction, which is expressed in election petitions. And the question that we need to answer in a bid to rejig, to reposition, to overhaul, and reconfigure our election petition is there a problem with our legal framework? Is there a problem with our institutional framework? If our answer is in the affirmative, the next question is, what is the actual problem? And then, can we say it's the inadequacy of our laws? Can we say it's the applicability of these laws or the enforceability of the law? Can we say the problem is the implementation of the law? Or can we say it's inherent technicalities that we have in these laws? Apart from this, we have the Constitution of the Federal Republic of Nigeria, which is the ground norm. And we see election in the Lagos Town Hall election of 1920. Apart from that, we see the introduction to general election in the 1922 Clifford Constitution, which birthed the 1923 general election. The extant constitution operative in Nigeria as we speak is the 1999 Constitution of Nigeria, which has the structure, the composition, the authority, and the autonomy of election petitions all embedded in them. Section 239 of the 1999 Constitution gives original jurisdiction to the Court of Appeal in the cases of election petitions arising from the election of the President and the Vice President, while Section 285 sub 1 and 2 gives original jurisdiction to election tribunals in petitions arising from gubernatorial elections, national and state assembly elections. We also see that the Constitution provides for the autonomy of INEC. Apart from that, we see the time frame provided by the Constitution in section 285 sub 5, where it provides 21 days within which an aggrieved party can file an election petition, and 180 days within which all these election petitions must have been sorted out. Apart from the 1999 Constitution, we have the Electoral Act, and the extant Electoral Act as we have it is the 2022 Electoral Act. That law, that act, is the basic law on which election petition is inked in Nigeria. The first test of that law, because it came to be in 2022, the first test was the 2023 election. And you will agree with me that there are still some form of technicality in that law. Technicality arising from the inclusion of the beavers and the IREFs, which has been held that also needs to the force of statute. It needs the force of law to come into proper being. Apart from the Electoral Act, we also have judicial precedent. Judicial precedent is another legal framework of election petition in Nigeria. And cases from superior courts, such as the Court of Appeal and the Supreme Court, form part of these laws in the election jurisprudence in Nigeria. However, where we have conflicting judgments, where we have the guilty now in court telling the aggrieved, go to court, and then we see judgments being thrown out of our court. In the words of Justice Nweze, these judgments have been held that they will haunt the jurisdiction of our election petition for a long time to come. Apart from this legal framework, we also have institutional framework, so INEC, and I'm glad to tell you that our electoral body has changed the name, the nomenclature, over the years, from Federal Electoral Commission, FEC, it went to Federal Electoral Commission, FEDECO, it went to NECON, and then finally, it is INEC. Maybe we were thinking that it was the nomenclature that was the problem. But apart from the name, how independent is our Independent National Electoral Commission? Even though the autonomy of this commission was provided for in Section 158 of the Constitution of Nigeria, 1999 as amended, where it provides that this commission shall not be subject of anybody or authority. However, it is alarming to know that the same constitution undermines this autonomy in its Section 154, where it gives the president the power to appoint his principal members. Quite apart from this, the funding of INEC, if we look at Section 3 of the Electoral Act 2022, even though it provides for a fund for INEC, and it also stipulates in it that these funds for election must come in 1 year prior to election, but the major funder of this commission is still the federal government, as it is in the common parlance. He who pays the piper dictates his tune. So, government will have the mind to interfere in their activities. Apart from this, we also have security agencies. Security agencies are law enforcement agencies, such as the Army, the police, the DSS, who are also their role to protect lives and properties. Apart from these noble roles, they have been used as pawns in the hands of politicians who use them to perpetuate irregularities, to aid corruption at elections. Apart from INEC and the security agencies, we also have the judiciary. And by this, I mean the courts and the election tribunals, as empowered in Section 239.
Please, you have 5 minutes to round up, please. 5 minutes.
Okay. Apart from
for the whole team.
Sherry, apart from this, we see judgments, like we said, judgments come in, conflicting judgments, which has actually is haunting the jurisprudence of election petition in Nigeria. I will now hand over to our dear Prof, who will now talk to us about real-life experience and then the analysis we have made from other jurisdictions. Thank you.
We thank you so much for listening with rapt attention. In the course of this paper, we identified the challenge of technicalities as impeding electoral jurisprudence in Nigeria. And we know that all the rules and regulations and the law, like the Constitution, the Electoral Act, the rules for election petitions, and other subsidiary legislations are geared towards the sui generis nature of elections, in such a way to ensure that adjudication of election matters are done speedily. Actual practice and from the pronouncements of our court, we realize that even though in civil matters or in ordinary matters, our courts are beginning to move away from the area of technicalities to do substantial justice. But however, we realize that the reverse is the case when it comes to hearing and determining election matter. A very good example is what happened in Osun State, that Justice Obiora did not sit on one day. Other panels had the matter, and the Supreme Court declared the decision of that tribunal as null and void for the panel not being properly constituted. We also realized in another case that the chairman of the tribunal took a motion and dismissed an election petition, even though the rules of court, the rules for the election petition allows a single judge to hear interlocutory application. But of course, at the Court of Appeal, that decision was set aside. Another area that we notice is the time allowed by the Electoral Act and the rules for the hearing of proving elections petition. The number of days given to the petitioners, like in presidential election, you are expected to prove your case within 7 weeks. And if you look at the requirement for proving an non-compliance, especially in the presidential election, I was privileged to be one of the counsels to one of the presidential candidates in 2023. And even assembling our evidence across the over 7,000 police stations in Nigeria was very, very difficult. So expecting someone to prove within 7 weeks makes it very difficult, very, very difficult in Nigeria for any petitioner to win at the presidential election tribunal, as the case may be. Another thing that we have, another issue that we have addressed in this paper is a comparative analysis or a comparative inquiry or a comparative examinations of the practice in other jurisdictions. And we look at Gambia. In Gambia, as small as it is, and I think it's the same thing with the Republic of Kenya, for you to win at the presidential level, you must have 50% plus 1 vote. That is, you must have a simple majority, because democracy is nothing but the rules of the majority. And whosoever aspires to lead his people, obviously and honestly, should have the majority of the popular vote, as the case may be. We also look at the United States of America, where all election matters
begin to round up now. Begin to round up.
We look at the United States of America, where election matters must be determined before the 20th of January. That is before the president is sworn in. And we do recommend that that also should happen in Nigeria. And then in South Africa, they have a specialized court, their constitutional court, that is charged with hearing also all election petitions. This actually free other judges to do their normal work. And in the course of time, because over the years they've been hearing and determining election petitions, they have actually become experts in this regard. And we so recommend that the time has come for Nigeria as a country to probably consider the issue of a constitutional court to address constitutional issues and also election petition. Thank you very much. May I invite my brother, Professor Obaje, to conclude. We are sorry. 1 minute.
Chairman, sir, mine is a recommendation. Chairman, the other presenters have said a lot about this topic. It's really a contemporary issue, and a lot of issues have been raised, especially the gaps in the laws. We are calling for a constitutional review. Thank God, because something is already ongoing. Constitution has to be amended. In the paper, we make mention of specific sections that are standing as clause in the will of petitions. Then again, the Electoral Act also is problematic in so many other areas. Time will fail me to mention some of the issues now. Then my learned professor had mentioned the issue of creating a constitutional court only for election, so that there can be consistency in decisions. Nigeria has come up from 1920 up to this level that we should be able to have a court that can handle only election matters. And in so doing, we will not have this issue of decisions that are contradictory. That's one of our recommendations. What is wrong with bringing in ADR mechanism into election matters? Not all matters have to end up by way of petition in court. Now, in so many of those things are there in the paper, and the time is gone. But then I want to add this, that now as a body, 56 years today, we are now saying should be able to have a say in some of this law review. And we are categorical.
Please, you can round up
a
now.
committee,
Yes.
a committee of law reforms, and then even on election matters. Now a review is going on, National Assembly. Won't stop now, even in the course of this meeting, to set up a committee to make a position paper to National Assembly on this boiling issue. And I think that when we do that,
Please, can
we
you
have a
stop
voice
now?
to be heard.
Please.
Thank you, and then we're grateful.
Please, can we put our hands together for the Federal University, Lokoja? I'm really amazed by the presentation of the lead faculty for quite a number of reasons. And we need to really put our hands together for them by the time I mention. Let me mention them. The lead person in the presentation is attending NALT conference for the first time in her life. Can we put our hands together for her? This is the real spirit of NALT. Somebody attending NALT conference for the first time and was made to lead the presentation. I know she will never forget today in her career. We thank you for the presentation. And other professors queuing behind their mentee to see how she presents and came together to support her. We thank them for this presentation. Can we put our hands together for them once again? Where's my phone? University, madam. Okay. So we take on Bio University, Kano, for 10 minutes. Thank you.
Good evening, members. My name is Dr. Hadia Aliyu, representing Faculty of Law, Bayero University, Kano. We are discussants to this paper that is just presented by Federal University, Lokoja. We feel honored to stand here before you to have a discussion on this important topic and on a well-presented paper. Thank you very much, NALT, for this opportunity. We have an issue that I think should come last, but I want to say it first. As a discussant, we did not receive the lead paper. Ordinarily, we should discuss what they have said and hammer on their strengths, their weaknesses, and then have our position. But that notwithstanding, we still have our own, and it's almost the same thing. So I will just concentrate on some key jurisprudential issues that we are able to highlight in our paper, so that we would not repeat the same thing with the lead paper. We have an issue with regards to the time limits. Just like one of the professors here mentioned, having to decide strictly between 21 days to 180 days of pronouncing the election results, we feel that the time limit does not usually allow for thorough adjudication as required by the Constitution. Similarly, we have an issue of risk of violating the right to fair hearing, because most at times the judges do not have the ample time to listen to all the parties, their witnesses, and to look at the evidences tendered in order to have a judgment that is very fair to all the parties. So secondly, we also raised the issue of local standard. As we have now, currently under our laws, it is only candidates or political parties that can be able to file a case of election petition before the tribunals. Sometimes this is causes problems because it is excluding other people or others that may be affected, or they have those that have legitimate grievances, but because they are neither party nor the candidates that participated in the election, they will be denied to bring an action. There is also the issue of substantial compliance that is raised by the Electoral Act, that the judges, in deciding on election petition matters, they should just look at if there is a substantial compliance with the law. This is not very clear. It is ambiguous, and it leads to judicial discretion. Judicial discretion is not a problem, really, under the legal system, but the problem is when it comes in different forms and shapes. That is, if it is inconsistent. There is also a risk of legitimizing electoral malpractice. These key jurisprudential issues have created a number of problems like declining public trust and perception of judicial bias. There is also an issue of judicial corruption and inadequate scholarly reasoning. There is also a proliferation of conflicting precedents, as I mentioned earlier. So we provided some suggestions that would take care of some of these problems. Providing clarity and harmonizing all our electoral laws, also strengthening judicial accountability. There is also the need to promote civic education and to improve public understanding of the judicial roles in election petitions. We conclude that Nigeria's election petition jurisprudence is at a crossroads, reflecting both democratic progress and systemic decay. So to restore confidence, courts must move beyond technicalities to uphold the popular will. A credible and coherent electoral adjudication system remains vital for peace, unity, and democratic stability in Nigeria. Thank you very much for listening.
Thank you very much. The representative of Barry University, Kanu, she did it under 7 minutes. Can we put our hands together for her again? And I must say that you did it very well, despite the fact that you did not have access to the lead paper. I'm sure that the lead paper will become more enriched by the time you pass across some of these, your comments. It's now time for representative of Al-Hikmah University, Ilorin, to make their own discussion. Thank you. Put our hands together for Professor A.T. Shehu, even though I've said I will not introduce you. Please, let's put our hands together for him, please.
Yes, thank you very much, the chairman, the Faculty of Law, Federal University Lokoja, and my distinguished colleagues. I will not waste much of our time because the earlier presenters, they have extensively dealt with the jurisprudential aspect of election process in Nigeria. But having said this, I still believe we have to continue discussing about it because we are talking of democracy. Election is the pillar of democracy. To get democratic stability in any country, we must get the electoral process very, very sound. But on page 9 of the paper by the local the university, I got it about 11 a.m. today, and I browsed through, and I discovered on page 9 of that paper, it is stated categorically that the law is not performing its duties to meet the aspiration of the Nigerian citizens. But again, when Professor Ankpita, SAN, the chairman, INEC, Independent National Electoral Commission, when he was delivering his message, he remarked that law serves as a tool for social engineering. Some will say for social transformation or for social control. But in the paper presented by the Lokoja people, they have told us that the law is not performing its expected responsibility. That is to say something is wrong somewhere. It is either the law has actually failed us or we have failed the law. If we have failed the law, then what do we do? I think this is where the problem lies. A lot of sections have been identified in the Constitution, in the Electoral Act, and let me quickly add also maybe Section 65 from Section 130 to Section 136 of the Electoral Act 2022. And again, Section 185 of the Constitution of the Federal Republic of Nigeria as amended. You see, some people have argued in favor of that section, but unfortunately, when you look at it carefully and you look at the type of practice we have in this country, you will realize that the time limit between 21 and 180 days may not be enough because of people, election, people, they have to go through several local governments to collate issues and all the rest of them. But at the same time, when you look at the time limit, you will realize that, yes, if time is not taken and you leave everything openly, then you may never get to the end of an election. If we have allowed election petition to drag so long in the case of the last presidential election, only God knows what will have happened now. But I believe certainly we may not have gotten our president by now. So I think we have to look at it carefully to balance the equation. Having said this, I want to throw some questions. And maybe that is where I will drop the mic. You see, you will realize that since 1999, the judiciary in Nigeria has been receiving bashing here and there for so many reasons. It is either we are talking about contradictory decisions. Somebody mentioned corruption. I will not mention corruption because I am a pro-judiciary. So I won't talk about corruption. I'm sorry for this. I won't talk about corruption. And again, I do not have any evidence before me. No judge of the Superior Court, I think I'm correct, has been convicted for corruption in this country. So to come on the podium here to allege that our judges are corrupt, you will need to prove this beyond every necessary doubt. I will say beyond So I think based on the doctrine of judicialization of politics and politicization of the judiciary, we need to, I'm happy I have one of our mentors here. We have Professor Idonije, we have Professor Kpokpola, and I think a host of others. We still have to look at this situation. Should the judiciary continue to be the adjudicator in electoral disputes? We have to look at that carefully. Another question is, should the president continue to appoint the INEC chairman? If we are talking of the rule of law in electoral matters, we need to ask ourselves that critical question. Should the president continue to appoint? I agree, Section 153 of the Constitution christened INEC as an executive body. But in real sense, should it be an executive body? When the executive is also participating in the election and the INEC is to be the umpire in the same election, then where is the rule of law? I think we need to, Professor, I've forgotten the name. He talked about, yes, see him coming, about comparative jurisprudence in election matters. I will also want to toe that line to let us see what happens in other jurisdictions where they appoint head of their electoral bodies. I want to talk about Canada, Iceland, Cape Verde, Mauritius, Brazil, Mexico, and of course, India. Let us see their model and design our own model so that we can save a lot of situations. We are saying rejigging for national integration, and which I want to see as rejigging our election jurisprudence for peace, security, and national development. So if that is so, then we have to look at those two questions very critically. Thank you very much for listening.
Please, can we put our hands together once again for Professor A.T. Shehu? He also did his presentation in 9 minutes. So we are very lucky to have those who are very conscious of time on this panel. And that's going to give us opportunity to take interaction from the floor. But before we do that, let me quickly reiterate that the lead presenters identify a lot of jurisprudential issues having to do with our election: autonomy, funding, security, conflicting judgment, technicality, time for hearing, before swearing in, and they made a number of recommendations: constitutional review, the amendment of Electoral Act, and having a special court handling election petition matter, possibility of looking into ADR mechanism in settling our election, and review general law reform generally. Now, again, Barrow University did a lot of intervention having to do with jurisprudential issues on our election matter. Violation of fair hearing, that relates to the timing and how they rush those who are to make presentation in defending their cases. And the issue of local standing for those who are really aggrieved, but they are not party members, they are Nigerians. They don't belong to a party, but because of that, they cannot even raise issue when they see one. And the issue of substantial compliance, that is discretionary, and the discretion of one judge will be different from that of another judge. Then legitimization of malpractices. You wonder where you have issue, and that also goes to the issue of autonomy. The executive has appointed the chairman, INEC, and most time you have the ruling party that has appointed INEC chairman. You have the opposition defending. You have lawyers representing INEC, and you have lawyers representing the ruling party. By the time you look at it, when the opposition lawyers, they ask for documents from INEC, you see a lot of technicalities. They will delay them, they will not allow them to have access, which will suggest that are they protecting the ruling party from the opposition? So these are a lot of issues that we need to interrogate. And I want to also mention the issue of defense lawyers. In most cases, you have opposition to be the one, the ruling party or the people in government are the one defending the electoral victory most times. They have access to the fund of the country. The other party does not have access to the fund. So they can get the best of lawyers, and sometimes, I'm sorry for our election petition lawyers, some of them receive their fund in dollars. This is not regulated. In other countries, how much can be charged for election petition is regulated, is not regulated here. How much parties can spend, these are issues that we need to all address. So I want to open the floor for our members to help us further interrogate these issues so that by the time Federal University Lokoja is amending their paper for the purpose of publication for conference proceeding, it will be more enriched. The floor is open now. Thank you. The General Secretary of the NALT want to make comment. Okay, let me identify those who are interested in speaking first so that we have 1, 2, 3, 4, 5. We have 5 people who want to make. Let's take those 5 first. If we still have time, we'll come back. Thank you. Please, you can give mic to him. Yeah, number 1. Thank you.
Thank you, Chairman, Professor Bicon, and the presenters and discussants. The topic is very relevant to the country at the moment, but I'd like to speak to it from an appraisal of 3 decisions of the Supreme Court. The decision arising from the Plateau State governorship election petition, the decision arising from the Kano State election petition decision, and then the decision arising from the Zamfara State gubernatorial petition. In those 3 cases, the Supreme Court made some very remarkable observations. One, that how a political party decides to sponsor a candidate has not expressly been provided for by the Constitution, and as such, if you are not a member of that political party, you have no business litigating it. Secondly, the Supreme Court remarked in those 3 decisions, the Supreme Court used the phrase judicial ethics. And from that, one can glean or infer that there's now an emerging jurisprudence of judicial ethics. My phone betrayed me. If not, I wanted to quote some of the language, very strong language of the Supreme Court against the lower court. In one of the remarks, the Supreme Court held that it amounts to judicial misconduct and illegitimate assumption of jurisdiction for a lower court not to abide by precedent or to ignore a clear provision of the Electoral Act or the Constitution. And in those 3 decisions also, I think my Lord Justice Agim, JSC, Justice Ogumiji, JSC, I remember, I forget the 3rd Justice of the Supreme Court now, but their language is so strong and weighty that I think we need to look at them closely to see the emerging position of the Supreme Court in relation to judgments that sometimes give us room to worry. I think in the Kano State Court of Appeal decision, there were 4 conflicting disposition orders, such that either the petitioner or the respondent could say that they won. So there was no clarity in it. So that's my contribution. Thank you.
Please, let's make our comments briefly, please, or question.
Thank you very much, Chairman. I'll be very brief.
You see, for elections, it must be won outside the courtroom. You know, if you want to have confidence in the system, you know, a situation where you hear go to court, because these politicians know that, look, they can only win in court, there's something wrong. And I think that's the essence of this conversation today, rejigging, you know, going forward. I'm a bit surprised that my friend Shehu would do corruption. I think here, we're not playing the ostrich here. We engage on this locally and see how we can find a way out of it. To say that there's no corruption in Nigeria, in our election matters, that's not correct. And I think you need to speak to, you know, some of our senior lawyers handling this matter. You'll get to learn some more. Rejigging, how do we go forward? In addition to the recommendations made, my first suggestion here is simply that we need to review the recruitment process again. You know, members of NALT, for instance, can also be made members of these tribunals and the judges as well. And I think it's important, and I agree with the chairman, the DG NALT, that INEC needs to be excluded as a party in election matters. That way they can come to, you know, the issues objectively and adduce all the evidence and avoid delays. Yeah. Thank you.
Number 3. The woman there, yes. The woman there is number 3. Number 3.
Chairman, while finding the paper presenters and discussants, an issue came to my mind.
Please introduce yourself, please.
Sorry, please. Professor Grace Akoloku, River State University.
Thank you.
An issue came to mind. In rejigging the jurisprudence of election matters in Nigeria, I listened to the presentation, and I think that an aspect that we need to consider is empaneling of election tribunals. The subjective method of always deciding on particular judges to go for this tribunal, and sometimes they will be repeating the particular judges for certain tribunals. NALT should take a position on that and suggest a more objective ways of empaneling these election tribunals. Maybe take away the powers from the CJN and put it in the NJC. Thank you.
The decision is the NJC.
Mr. Chairman, I am Professor DJ Osman, Faculty of Law, Bayero University, Kano. My first intervention is in the area of standard of proof. I think there is need to review the stance of the election petition tribunals on the standard of proving criminal allegations in election petition. The provisions of the Evidence Act is being used, but if we look at it, Section 138 of the Evidence Act says, in any proceedings, civil or criminal, where crime is alleged, the proof is beyond reasonable doubt. Now, the authorities are replete that election petition is neither civil nor criminal. It's hybrid. In that context, it's sui generis. Now, why should the law insist? You are just coming to prove that this election does not meet the minimum standards. And where even crime is alleged, after the decision of the tribunal, nobody will be sent to jail. Why should you raise the standard to be beyond reasonable doubt? I think it should be on a minimum standard of showing that there were irregularities, not to prove it beyond reasonable doubt. Because it has been used as a basis of dismissing several petitions. They would always say, there is violence, there is thuggery, the proof is beyond reasonable doubt. And I think that has to be revisited. And secondly, the rules of election petition are unfairly against the respondent. If you look at a jurisprudence that is emerging, is that if you file an election petition and the respondents respond to the petition, you as the petitioner not file additional evidence in support of your reply, even if there are new issues. The only thing you can do, you can only file a reply. Now, the basic rules of pleadings are that pleadings are useless without the evidence. But the authority as it stands now, you can only file a reply and you cannot accompany it with additional evidence to your reply as the petitioner. So whatever the respondents raise, even if it is baseless, the highest you will do is to file pleadings without accompanying evidence. And then also the other issues are the conflicting decisions. If you've been part and parcel of the last election petitions, at the Court of Appeal in particular, you realize that after a panel might have delivered judgment in similar issues, the next panel may give a different position that is conflicting. And there's also the issue of lack of following precedents by the Court of Appeal. There are occasions when there is an established decision of the Supreme Court or an established decision of the full court of the Court of Appeal saying that a particular issue has to go this way, but the Court of Appeal has decided cases that are against the established precedent by the Supreme Court. Thank you.
Thank you. Thank you very much.
Mr. Chairman, my name is Oyeleke Oyenira. I'm from Caleb University. Now, my question or intervention is this. On the 18th day of April 2023, Guardian newspaper and other reputable newspaper reported that lawyers coming to Rivers State to file election petition were arrested at the airport and they were frustrated. We agree in this session that election petition is time-bound. So if we have jurisprudential approach that arrests lawyers, scares them from doing their work, don't you think it is time that we import a system that protects legal practitioners involved in these cases from harassment, from being bullied, so that we can have a level ground situation? Thank you very much. My name is Leke.
Thank you. Thank you. Yes, in Yoruba parlance, they will tell you, if two young ones are fighting, and one of them use his teeth to cut the other one to win the fight, they will say it's part of fight. So you can win anyhow. So if you have the security at your disposal, you ask them to arrest the lawyers that are going to file petitions so that they will be out of time. It is part of the system. So these are some of the issues. You are right by that statement. But it's not just about the right of the lawyer being harassed. It is not the lawyers that were targeted. It is the timing. They don't want them to be able to file within time. And if they are arrested, all their processes were confiscated, and they were released after the time they have to file the petition, there is no petition again. So you have made a point. I think the panelists will have to make a response to some of the comments made. We start with the lead. Okay. Please, excuse me, please. We have taken 5 people from different parts of the hall. We may not be able to take everybody. I remember we took somebody from this role. Okay. So we respond to this. If we have more time, we can take more. Thank you. Federal University, Lokoja. Any response?
Now, as on the issue raised concerning judgment from the tribunals in Plateau State and Kano, and then the different decision on the same facts at the Supreme Court, indeed is very unfortunate. And the question of late, whether all election petitions appeal should end up at the Supreme Court. Of course, fortunately, I'm one of the consultants to the Senate on the review of the Constitution, and we have raised that issue with the bench of the Supreme Court. And the Supreme Court of the opinion that they are actually clamoring for their jurisdiction to be reduced so that they can only handle specific matters. But in the situations that you have matters or cases whose facts are on all fours between the gubernatorial elections and that of the legislative houses, and yet the Court of Appeal decided to the Court of Appeal gave a decision that is completely opposite of that of the Supreme Court in case of the gubernatorial election, actually questions the integrity of the entire electoral process in Nigeria. And what is left for us to decide, even at this gathering, is whether all election petitions should either end at the Court of Appeal or at the Supreme Court. Thank you very much. Then on the issue raised by my colleague on the other side, the lawyers that were arrested in Port Harcourt. Now, the question we should ask ourselves is how come that Nigerians are not being prosecuted for electoral offenses? The argument of INEC is that they lack the capacity to prosecute, and then ordinarily would have expected the police to prosecute. I just came back from Lagos where we had a retreat on the review of the Constitution, and we're actually proposing by way of constitutional amendment to have an electoral offenses commission, which I think that amendment to the Constitution will say true. My colleagues will throw light on the other issues that have been raised.
Barrow University. Okay, no comment? No comment. I think we already ran out of time, and I want to apologize to our colleagues that will not be able to take their question or comments again. You realize that we started this session very late, and we have even spent, when the moderator was saying they gave us 45 minutes, I just said, just give me the mic, whether you are going to take it from me when I'm extending your 45 minutes. We're entitled to really have a robust discussion, even much more than the time we gave to our politicians in the MBA. So I want to thank everybody that has participated in this session, starting with our lead faculty paper presenter, that's Federal University, Lokoja, Barrow University, and Al Hikma University. Please, let's put our hands together for them once again.
Thank you so much.
And in closing, my name once again is Professor Abdulkadir Ibrahim Abikan, the DG, Nigerian Institute of Advanced Legal Studies. Thank you. Thank you. Thank you.
Thank you so much.
So we take photograph of the session.
Yes, please.
If the chairman of the BOT is around, Mr. President, please join us in taking the photograph of, and the chairman LOC, please. Thank you.
Thank you so much. As the photographs are being taken, we'll be taking some few announcements. In the next 10 minutes, I believe that will be out of this place. But I want to especially appreciate this wonderful panel. And they've all pointed out to the fact that something has to be done about our electoral jurisprudence. And my prayer and wish is that NALT should package these recommendations. And thank God we have a member of NALT as the INEC chairman, that he does something about these problems going on within the electoral system. I was privileged to be a member of the panel of Anambra State Election Tribunal for the local government. And one thing I found out was that the laws are stacked against the petitioners. And regardless of how much I wanted to make sure that I do justice, the laws were against the petitioners. They could not meet up with the time. They could not meet up with a lot of requirements that are there by the law. At the end of the whole day, they withdrew their petition. And we didn't have any option. I wanted to do justice, but we didn't have an option but to leave. These things have to be dealt with immediately if we would have free and fair election and if we would vote in the right people into office. So thank you so much to this panel. Another round of applause for them. They've done a very wonderful job. I want to announce that all sessional papers slated for today will take place first thing tomorrow morning by 10 a.m. Sectional paper 1 will take place at this place, this hall. Sectional paper 2 will take place at the lecture hall 1. Sectional paper 3 will take place at the lecture hall 2. Sectional paper 4 will take place at the moot court behind the canopies. I was also asked to announce that the health walk will start by 6:30 a.m. tomorrow, and the buses will be available by 6 a.m. tomorrow to pick all the interested persons to University of Abuja Mini Campus Faculty of Law. Please also remember that the social night at the Friendship Center, Thursday Hotel, will start by 7 p.m. this night. And I would also ask you to please do not forget that my name is Dr. Rapolo Ndoka for obvious reasons. Thank you so much and enjoy the rest of your evening. God bless you. Please, finally, let me also announce that the Administration of Criminal Justice Academy has a special package addressed to 39 law faculties, to the deans of 39 law faculties in Nigeria. Please, the packages can be received by the deans themselves or a lecturer or a representative of the law faculties. I will not invite a member of the Administration of Criminal Justice Academy to please read out the names of the faculties that are meant to receive these packages before we go. Please, it is important. It is a package. It is beneficial. Thank you.
Thank you. Thank you very much. The dean hello. So the relevant faculties are as follows. University of Ibadan, UNN, Imo State University, Niger Delta University, Usman Dafodio University, Olabisi Onabanjo University, University of Calabar, Obafemi Awolowo University, UNILAG, University of Lagos, University of Port Harcourt, Rivers State University, University of Maiduguri, Nigerian British University, Northeastern University, University of Benin, Ambrose Ali University, Abia State University, Enugu State University of Science and Technology, Northwest University Kano, Admiralty University, Edo State University, Osun State University, Adekunle Ajasin University, Bauchi State University, Benson Idahosa University, Umaru Musa Yar'Adua University, Edwin Clark University, Ebonyi State University, Gombe State University, Delta State University, Afe Babalola University, Covenant University, Bowen University, Ahmadu Bello University, Lagos State University, Bayero University, Federal University Otueke. So please, if the representative of these faculties are around, so you can just kindly acknowledge and receive the package. Okay, this is a letter from the Administration of Criminal Justice Academy for this faculty. I'm with you, sir, just to take it from me now. Okay.